Objection, man.
Mr. Hensley.
I drive a BMW. Anybody with an autopilot vehicle, you know for a fact it won't do that. Malik Bey.
All right. So, Mr. Hensley, we've been through this before. I'm going to call you by the name that's found on the information here.
You have my nationality information. You have my.
So, Mr. Hensley, are you representing yourself today?
Proper persona sui juris.
All right. Are you representing yourself today, sir?
Propria persona sui juris.
All right. So, Mr. Hensley, I'm not certain what you mean by that phrase. All I'd like to know is that whether you're representing yourself today or not. We've had this conversation many times previously. It's up to you, sir. All right. So, Mr. Hensley, you don't have a response for the court?
Well, you don't know what proper persona sui juris is? That means somebody presenting themselves.
All right. So is that what you want to do, is represent yourself today?
I'm presenting myself, Islam, yes.
Okay. And then, as we've talked about several times, do you understand that representing yourself can put you at a disadvantage to other folks like the people who have attorneys that are representing them? Do you understand that?
No, I do not.
Okay. What don't you understand about that?
None of it.
You don't understand any of it?
I don't understand it has a disadvantage.
You don't understand what?
Did you say it's a disadvantage?
Yes.
How's a disadvantage? In what term? In what manner?
So the disadvantage would be that they're familiar with the rules of court, that they're trained lawyers and the rules of evidence and things of that nature. Things that we've discussed.
Hey guys, and welcome to today's video. What starts as a routine courtroom appearance quickly turns into a lesson on how not to handle sentencing. From the very first exchange, you can sense resistance instead of cooperation. The court is trying to establish something simple, representation and procedure, but the defendant chooses ideology over clarity. These moments matter because this is where futures are shaped. Instead of focusing on outcomes, we see technical language, objections, and misunderstandings take center stage, setting the tone for everything that follows.
As complete as we can, but I want to do that in person because we can do this all morning via Zoom and it's just not very conducive to that. So if he can be brought over, and then we'll continue with our doctor until we see him here. What do we have next that we can do?
Yes, sure, we call the case People v. Lowell Schwartz, case number 24S. Case number 23S18766 FH, People v. Milton Hensley Bay Jr. Defendant is present. He is in person. He is in pro-per. Today's the administrator for sentencing. And in front of him at the podium, I've provided 2 copies of his right to appellate.
All right. So, Mr. Hensley, we are back this morning for Sugar Court sentencing. He's appearing in person. We did try to start this earlier with him remote at the jail. It just made more sense for the court to have him present where we're not trying to talk through Zoom. So, Mr. Hensley, here we are again today, sir. First, I want to start with this. When I arraigned you a couple weeks ago, you were given the opportunity to request court-appointed counsel, and you were also given the opportunity for the last several months to retain your own counsel. Are you representing yourself today, sir?
For objection, for the record, make the record reflect. My appellation is Malik, title is Bey. Works American National, I'm the Islam.
Here, the judge carefully explains the risks of self-representation, outlining how attorneys are trained in rules, evidence, and legal strategy. This isn't intimidation, it's transparency. The court is making sure the defendant understands the disadvantage before moving forward. But comprehension never lands. What should be a straightforward acknowledgement turns into circular debate. This is a critical crossroads, because once the court confirms informed choice, responsibility shifts entirely to the defendant. From this point on, every consequence is tied directly to decisions being made in real time.
All right. So you're not going to answer the court when I'm asking, do you wish to proceed representing yourself today for circuit court sentencing? You wish to do that, Mr. Hensley?
Objection. My appellation is Malik, title is Bey.
All right. So then let's get this on the record. As far as the PSI, Ms. Bond, it would appear that the court has a copy of this. Mr. Butler apparently has it. And then what do you know about Mr. Hensley receiving this copy? So Mr. Hensley, have you had a chance to review the pre-sentence report, sir?
Objection. My appellation is Malik. Title is B. And for the record, you have my nationality information within your files. So you know my appellation.
All right. So when was our PSI completed, Ms. Bond? Looks like 2/29 of 04.
Yes.
Got it, reviewed it. And so after the review, that would have went out to all the parties sometime in March. So I also want the record to reflect, I've seen Mr. Hensley several times.
As proceedings move in person, the court resets and tries again to establish representation. This isn't repetition for show, it's due process. Judges must document every opportunity given, every right offered, and every refusal recorded. You can feel the patience wearing thin, not from emotion, but from procedural necessity. Delays, missed chances, and repeated non-answers all begin to stack up. The court recognizes a pattern forming, and at this stage, the focus shifts from accommodation to resolution.
And entitle, I should say, the defendant to the assistance of an attorney, which is why I'm asking. However, the court is balancing that with the idea that this circuit court sentencing date has been delayed several times, and the court can't help but glean at this point it just appears to be a delay tactic. The court, we sift that back through the dates, has given Mr. Hensley several times to hire counsel. He expressed that interest. Again, it appears in hindsight that it's simply a delay tactic. Court has given Mr. Hensley several times, actually not even with the sentence that the court's required to give here in a moment, keeping him out on bond to do those things, explore counsel. Even after being arrested on the warrant when he failed to appear, court also gave him the opportunity again to request court-appointed counsel. In fact, the public defender's office appeared at his arraignment. Mr. Hensley Bays had the ability to fill out the affidavit and request counsel. Here this morning, in response to the court's questioning, he does not appear interested in answering the court's questioning. Again, it appears to be a delay tactic. I am comfortable that the pre-sentence report has been provided months ago to Mr. Hensley.
Now the sentencing phase takes shape, and the gravity of the case finally comes into focus. Victim impact enters the record, transforming abstract charges into real human consequences. This is where legal theory collides with lived experience. Families describe fear, trauma, and lasting emotional damage. These statements matter because sentencing isn't just about punishment. It's about accountability and protection. The court evaluates psychological harm, the presence of a child, and ongoing therapy, all of which directly influence how serious the outcome becomes.
Mr. Hensley's been engaged with this. We have several filings that are not court filings that he has continued to send to the clerk's office, some of which he has referenced, none of which have anything to do with the case and or the court's requirement to get him sentenced now that he has been convicted several months ago of these crimes. So what I'm going to do is I'm going to start with then Mr. Butler. As it relates to the PSI, are you aware of any corrections, additions, or deletions that need to be made with it other than what we've already placed on the record with probation?
I would just ask the court to take a look at offense variable 4 regarding psychological injury to the victim. We did receive a victim impact statement. It looks like it came from Robert Siegel, who was the male occupant of the vehicle. In this case, the victim. We received that just this morning, about 2 hours ago. By email. So I can read that. I do believe it references facts to validate scoring for week 4.
All right. So why don't you read that?
Okay. This is from Rob Siegel. That's Siegel. He says, I do have things to say.
When objections surface, the court explains how impact is evaluated under sentencing guidelines. This isn't about proving every emotion with paperwork. It's about whether the harm meets legal thresholds. The judge walks through that reasoning step by step, tying testimony to established standards. At the same time, the defendant continues to reject responsibility, framing everything as accusation rather than consequence. But convictions already exist. This phase is no longer about guilt. It's about determining a sentence that reflects risk, behavior, and the lasting effects on others.
Her life short for seemingly no reason at all. My wife had to start and is still in therapy over this whole situation, which has thankfully helped her anxiety levels to become manageable, but also is not covered under our insurance. So it's cost us quite a large sum of money, and that brings with it its own stresses to our family and social life. I find myself driving and cannot seem to relax because anyone I see speeding up behind us reminds me of the terrible people in the world and just how ignorant someone can be with disregard for others' lives, including those of its own family and child in the car. Being that there are previous charges against Mr. Hensley for almost the exact same situation where he brandishes a gun and threatens to kill people because of his unchecked aggression and inability to safely operate a vehicle, which then turns to road rage, I plead that the court recognize this man is a danger to society whose blatant disregard for human life will eventually cost someone to lose theirs, if not his own. Because of all the pain, sufferings, financial burdens, and overall creation of trauma and issues in the many lives he's affected, I petition that the court give Mr. Hensley the maximum sentence possible for his crimes, that my family and others he's affected may know some semblance of peace. To Mr. Hensley, despite everything you've done to my...
The judge then revisits the underlying conduct, explaining how aggressive driving escalated into something far more dangerous. Introducing a firearm changes everything. The court highlights how these choices put multiple lives at risk, including the defendant's own. Past similar behavior is discussed to establish pattern, not punishment. This is about public safety. The message is clear. Actions on the road can turn fatal in seconds. The court emphasizes that escalating conflicts with weapons is exactly how tragedies begin.
Hensley, what is your objection?
Tell him prove everything he's saying. If his wife and everybody went through the trauma, show me the doctor bill and report that he went through it. Because I can't believe somebody that was slamming the brakes on the interstate at 75, 80 miles per hour dealing with trauma. You could have killed us and everything behind me. Ain't no such thing as you got trauma for you slamming your brakes.
All right.
Prove the accusation that you made. Prove it.
All right. So, sir, I am
Instead
going
of
to
reading the
grant.
script like you coming from a movie or something.
I am going to grant the request for scoring OB4 based on the victim impact statement here. It does appear to meet the definition. Now, OB4, for the record, psychological injury to a victim could be scored 10 points if the serious psychological injury may require professional treatment, and in making the determination the fact that the treatment has not been sought is not conclusive. First, we have the issue of the 9-year-old in the car, apparently with special needs, and dad, victim, as expressed in that statement that was just read into the record, how this is still affecting the minor child. And that makes sense to the court as it relates to somebody that's 9 years old and was observing somebody pull up next to them and point a handgun at them.
Still haven't been proven for the record.
Mr. Hensley, you've been convicted of that, sir, by the court.
We're gonna have our
Okay.
We will have our
So please let me finish, and then I
Yeah,
certainly
continue.
will give you the opportunity to address the court before sentencing. And then also, pursuant to the statement that was just read into the record from the wife, who also was in the car, according to the testimony at the trial, she is not only suffering from the effects of this, has sought treatment and continues to seek treatment, which is in line with the OV scoring guidelines that professional treatment may be required, in fact has been, and is still being engaged. So we'll score 10 points for OV4. So that will change our total OVs to 35. And does that change the level?
Judge, I changed it to a level 4, and so a C4 cell is going to be 523.
All right. Any other additions, corrections, or deletions from the people?
No, nothing from the people, and nothing else from the people.
So you've read the statement into the record, then nothing else from victims,
That's correct, Your Honor.
and then anything on behalf of then the people.
Your Honor, the recommendation on the 0 to 17 guideline range is 12 months on count 1 and 2, and 2 years on count 3 preceding the count 2 sentence. The people did initially support that, but with the change in the sentencing guideline range, obviously this does open up, Your Honor, to more opportunity for incarceration if you so choose, and we would leave that at discretion. But otherwise, we ask that you at least follow the recommendation as intended.
All right. So, Mr. Hensley, I'm going to give you the opportunity before I ask you to address the court for sentencing. Do you have any additions, corrections, or deletions as it relates to the pre-sentence report?
Yeah, I can say.
Do you have any additions,
Accusations.
corrections, or deletions?
All those accusations are false, and none of them have been proven.
Okay.
Not one. And he talking with this story.
As it relates to this report, do you have any
I don't have
additions,
no report.
corrections, or deletions? Excuse me.
No, I don't have a report.
All right. So, as it relates to sentencing, is there anything that you want to state to the court before a sentence is imposed?
You know, I have my medical information. You know, I have stage 3 cancer. You know, I have head trauma. You know, I have neck and back injury. I suffer with a dry foot. For the record.
Anything else then,
That's
Mr.
it.
All right. So Mr. Hensley has provided, it is accurate, information regarding different medical issues that he is suffering and is suffering today, as a matter of fact. However, as the court sat through this trial, it's clear to the court that what Mr. Hensley was engaged in is troubling. The testimony of these victims, where they were traveling on westbound I-96, minding their own business, when Mr. Hensley's vehicle comes up behind them at a high rate of speed, the victim described with great clarity how close Mr. Hensley and his vehicle were to them, to the point they were extremely uncomfortable.
Objection.
Did not, hold on, Mr. Hensley, let the court finish, okay? To the point that they thought they were going to be struck. The victim, I recall, describing being unable to even see the front of Mr. Hensley's vehicle. That's how close it was, meaning the grill, headlights, I recall the testimony, and that they immediately got over. The victim then went on to describe that Mr. Hensley pulled up next to them and pointed a handgun in this manner, of course, pointing over to the right and directly at these individuals. The victim described how he reached back, started to shield his family, and that they were getting down as best they could. Now, all of that, I think, is certainly actions that would cause the victims here to feel their life was in danger if somebody points a gun at them. The fact that somebody is tailgating back closely behind them on the highway at speeds of 70, 75, 80 certainly puts people in danger, could cause people to be incredibly uncomfortable about what's going to happen next. But it's a long way, Mr. Hensley, the court saying, having sat through the trial, you create the situation by driving in a manner that makes these folks uncomfortable, by coming up on them at a high rate of speed and following them that closely.
Objection, man.
Mr. Hensley.
I drive a
Two
BMW.
objectives.
Anybody with an autopilot vehicle, you know for a fact he won't do that.
Right.
That's a
So-
fact.
So Mr.
Not what
Hensley,
he giving you on out of his mouth. A fact. An automobile will not get up on nobody automatically jam brakes. I told you
Trial.
BMW does that.
the trial is over. You had
Oh,
an
it's not over.
opportunity
It's not
to
over.
cross-examine those witnesses.